Like before, when the broker-dealer applied for registration, the SEC will grant registration when? Within 45 days. Same thing for the investment advisor that applies for registration. Within 45 days of the filing of Form ADV, the SEC shall grant registration or institute proceedings to determine whether registration should be denied. FINRA Rule 3160 outlines the procedures for what they call networking arrangements between members and financial institutions. I'm sure you've seen this. When you go to your bank, you can oftentimes at the bank buy securities. So these rules are for that sort of a situation. When a bank has an arrangement with a broker-dealer and the broker-dealer is engaged in the practice of selling securities on the premises of a financial institution where retail deposits are taken. So it's a very specific rule for this sort of a situation. So it starts with this: wherever practical, broker-dealer services shall be conducted in a physical location distinct from the area in which the financial institution's retail deposits are taken. So it's not like you can walk up to the bank teller and buy mutual funds, but there's a separate, usually office off to the side, where the broker-dealer conducts its business. In that separate area, the broker-dealer's name shall be clearly displayed. So there's a sign usually. There are specific customer disclosures that must be given at or prior to the time that a customer's securities brokerage account is opened by a broker-dealer on the premises of a financial institution where retail deposits are taken. The broker-dealer shall disclose both orally and in writing that the securities products purchased or sold in a transaction with the broker-dealer are not insured by the Federal Deposit Insurance Corporation. So the FDIC protects the money that the customer has in the bank, but FDIC coverage does not cover securities brokerage accounts. Orally and in writing must also be disclosed that the securities products purchased or sold are not deposits or other obligations of the financial institution and are not guaranteed by the financial institution and are subject to investment risks, including possible loss of the principal invested. So the $10,000 the customer is giving as an investment today might be worth $1,000 tomorrow. They might be worth nothing in the future. So this must be disclosed orally and in writing anytime the broker-dealer does business at a bank. The broker-dealer must make reasonable efforts to obtain from each customer a written acknowledgement of these disclosures having been made both orally and in writing. So notice the way the rule is written. They have to make reasonable efforts. They don't have to get a written acknowledgement of this, but they have to make reasonable efforts to get a written acknowledgement of this. This rule also discusses communications with the public. All member confirmations and account statements should clearly indicate that the broker-dealer services are being provided by the member. So a lot of times we've got the bank and then we've got the broker-dealer portion of business and their names sound very much familiar, very much similar, but they're not the same. So it has to specifically use the broker-dealer's name on all confirmations, on all account statements. The rule also states that retail communications, including material published or designed for use in radio or television broadcasts, ATM screens, billboard signs, posters, and brochures that announce the location of a financial institution where broker-dealer services are provided by the member, or promote the name or services of the financial institution, or that are distributed by the member on the premises of a financial institution, or at such other location where the financial institution is present or represented, shall include the disclosures required by this rule. The following legend may be used to provide these disclosures in retail communications, provided that such disclosures are displayed in a conspicuous manner. So there's going to be three things. I urge you, the next time you're at the ATM, seems like a lot of times there's an ad. Who reads it? Nobody. Well, I don't normally, except for the fact that this is my job. So there I was putting a check into the bank, And there was an ad for brokerage services that I could go into the bank and do with, of course, the broker-dealer. And right there on the ATM screen were these three things. Why? Because they're required by FINRA rules. Not FDIC insured. No bank guarantee, may lose value. So it was basically an advertisement for broker-dealer services, and it had to include, it was on an ATM screen, how strange, had to include those three disclosures. It is true that in certain situations, those three disclosures do not have to be included. If the advertisement is a radio broadcast of 30 seconds or less, then it does not have to be included. Certain banners and posters, it does not have to be included. But it was there on the ATM screen, so that's a rule for broker-dealers doing business on the premises of a bank where retail deposits are taken. Next, we have the NASD rule that's commonly referred to as the taping rule. This rule's been around for a long time. We still haven't yet updated it to have it be a FINRA rule. What this rule has to do with is certain firms will be required under FINRA rules to tape record all of the conversations that their registered reps have with customers. Now, it might be that a firm just decides to always tape record conversations, but the test doesn't really care about that. It's, do you understand what would make a firm required to follow the taping rule? So firms can choose to tape things if they'd like to, but sometimes firms have no choice but to follow this taping rule. So if a firm is notified by FINRA, which of course the rule references the NASD still, that they're subject to the taping rule, or if the firm realizes themselves that they're subject to the taping rule, the firm has 60 days to implement the procedures that it needs to have to implement this rule. This rule requires the tape recording. It requires written procedures regarding telemarketing activities. It requires specific supervision rules. Anytime a registered person is talking to a customer, an existing or prospective customer. Some firms will be subject to this taping rule. So let me give you a little bit of more maybe current information about this. So one of the things that FINRA is looking for right now in its annual letter as far as things that FINRA is after right now. They use the term cockroaching. Sounds awful, it's just a terrible word. What they're doing is they're starting a system where they can track people that left a firm because the firm was doing something wrong and where they went to. And kind of, I guess that's the cockroach? I don't know. Yeah, that's the idea behind it, is that certain firms will be subject to the taping rule if they employ too many associated persons that used to work for what we call a disciplined firm. So it's this idea of when a firm is done wrong, and a lot of times they just close down. Sometimes they close down, they file bankruptcy, nobody gets paid the money they're due, which all of this, of course, breaks my heart. And then those registered reps go to work at other firms, and oftentimes they go together kind of in this group, and it's not always good. So that's really kind of where the background is for the taping rule, and it is something that FINRA is currently really trying to develop procedures electronically where they can kind of look at this practice, where the people that left the firm all kind of stay together and go to another firm, which then gets closed down and so on and so forth, and it's not always good for the public. So what would require a firm, what would subject a firm to the taping rule? So a firm that has at least 5 but fewer than 10 registered persons, where 40% or more of its registered persons have been associated with one or more disciplined firms in a registered capacity within the last 3 years. So it's where they used to work for that we're looking at, a disciplined firm. So if more than 40% or more, if it's 5 to 10. So registered reps at the firm. So the firm employs 5 to 10. And this is when the taping rule, they become subject to the taping rule. 40% or more are from, in the previous 3 years, disciplined firms. So it's really where they came from that was bad. It's not necessarily that they got in trouble. It's that the firm that they were with got in trouble. So it's 5 less than 10. 5, let's make sure I say that the right way. 5 but less than 10. All right. So then we get to a bigger firm. A firm with at least 10 but fewer than 20. So a firm with 10 registered reps but less than 20 registered reps, where 4 or more of its registered persons have been associated with 1 or more disciplined firms in a registered capacity within the last 3 years. So that's the second rule, 4 or more. Subjects it to the taping rule. So 20 or more registered reps, what would subject this firm to the taping rule? 20% or more of its registered persons have been associated with 1 or more disciplined firms in a registered capacity within the last 3 years. 20% or more. Okay. 40% or more is the first, 5 less than 10, 10 less than 20, 4 or more, and then here's a percentage again. So what is a disciplined firm? A firm that they came from. A disciplined firm, by definition, either a member that in connection with sales practices involving the offer, purchase, or sale of any security has been expelled from membership or participation in any securities industry self-regulatory organization, or is subject to an order of the SEC revoking its registration as a broker-dealer. Member firms that become subject to the taping rule have how long to implement the rule? 60 days. Now, when a firm becomes subject to the taping rule, the very first time, it has the ability to do something unique. The broker-dealer may choose to reduce its staffing levels to fall below the thresholds that subject it to the taping rule. They would need to do that, however, within 30 days after they receive notice that they're subject to the taping rule from the NASD, which of course is now FINRA. So they can reduce their staffing levels to fall below, so whatever they need to do to get below the requirement so they won't meet the taping rule anymore, they can do that. The procedures required by this rule include supervisory procedures. Number 1, the tape recording of all telephone conversations, which we said, registered reps to existing or potential customers. The member firm shall establish procedures for reviewing the tape recordings made to ensure that all of those conversations are being held in compliance with applicable securities laws and regulations and applicable FINRA rules. All tape recordings, so this whole big rule, right, the taping rule, all tape recordings made must be kept by the member firm for 3 years, the first 2 years readily accessible, which is a very common rule. A lot of FINRA rules follow this rule, as you'll learn later on in the course. So tapes made shall be retained for no less than 3 years from the date the tape was created. Each member shall catalog the retained tapes by registered person and date. So 3 years from date of recording by person and date. Procedures required by the taping rule. So supervisory procedures must be maintained for a period of 3 years also from the date that the member establishes and implements the procedures. When a firm is subject to the requirements of the taping rule, they must submit to FINRA a report on the member's supervision of the telemarketing activities of its registered persons quarterly. So quarterly reports are made to FINRA. So we also had quarterly complaint reports made to FINRA. The complaint reports, though, were due by the 15th of the month after the end of the quarter, right? This rule for this taping rule says that these reports are due by the 30th day of the month following the end of each calendar quarter. So by April 30th for the first quarter. By the 30th of the following month. So it's, hey, look, you hired some people that left some not very good firms. So we want to make sure that you are listening in on what they're doing, because they might have been taught something wrong. So are you listening? Are you supervising these people? It's a really important rule. The Securities Act of 1933, I had to introduce that to you already. I couldn't help it. I couldn't talk about what was a security without telling you what a non-exempt and an exempt security was. So the act that requires registration is the Securities Act of 1933. All new issues, it's the very first date you ever need to learn. So it regulates the very first time a share is sold. All new issues are regulated. They required to file paperwork. It's the Paper Act. Requires full and fair disclosure of all material facts. It's hopefully preventing fraud and misrepresentation in the interstate sale of securities. So anytime securities are going to be sold across state lines, securities must be registered federally with the SEC. So we have some definitions under the Securities Act of 1933 that we need to feel comfortable with. The term sale or sell shall include every contract of sale or disposition of a security or interest in a security for value. The term offer to sell, offer for sale, or offer shall include every attempt or offer to dispose of or solicitation of an offer to buy a security or interest in a security for value. So I can offer to buy a security from you or offer to sell a security to you. You can say no thank you, and then the sale itself is the act of conveying ownership for money or other value. Any security given or delivered with or as a bonus for the purchase of securities or the purchase of any other thing is considered to have been offered and sold for value. So the weirdest things sometimes show up. You bought a new car, you got a Ford, and they gave you a share of Ford stock. How weird. That's never going to happen. It's an offer and a sale under the Securities Act of 1933. Rights, offerings are offers of securities. Warrants are offers of shares of common stock, and convertible securities are convertible into shares of common stock. So they're offers of securities. So in a subsequent chapter, you'll learn all about rights, warrants, and convertible securities. The Securities Act of 1933 defines prospectus. So prospectus means any prospectus, notice, circular, advertisement, letter, or communication written or by radio or television which offers any security for sale or confirms the sale of any security. Whenever the SEC passes a rule under this act, so the Securities Act of 1933, underneath every federal securities law are always a bunch of rules. So anytime they pass a rule under this act, it must be passed with the intent of providing protection to investors. They must think of whether the action will promote efficiency, competition, and capital formation. So those are just kind of some buzzwords within the outline that I wanted you to feel comfortable with. So new issues raise capital for the issuer. So we want to make sure that we're promoting efficiency, competition, fair competition, I suppose, and capital formation. Under this act, it requires all non-exempt securities before they're sold across state lines to be what? What do you think? What does non-exempt mean to you? I already taught you this. Must be what? Registered, of course. So it would be prohibited to sell a security across state lines unless it was registered. It has been effective. The registration statement has been filed and the SEC has cleared the issue for sale. So no use of interstate commerce through the mail, through the mailing system, they'll say it something like that, unless the security you're offering for sale is registered or you're offering an exempt security, because an exempt security need not be registered. Section 17 of the Securities Act of 1933 says it is unlawful for any person in the offer or sale of any security by the use of any means or instruments of transportation or communication in interstate commerce, or by the use of the mails, directly or indirectly, to employ any device, scheme, or artifice to defraud. It just sounds bad. So do not do that. Do not attempt to obtain money or property by means of making an untrue statement of a material fact. So the prospectus is a summary of the registration statement, and it doesn't have to disclose all facts, but it does have to disclose all material facts. It would be prohibited to engage in any transaction, practice, or course of business which operates or would operate as a fraud or deceit upon the purchaser. Prohibited under federal securities law. It is considered unlawful for any person to use any sort of advertisement, whether or not it's a notice, a circular, a newspaper, article, letter, investment service, or communication, which, though not purporting to offer a security for sale, describes the security when they've been paid to make such sort of a mention. So they can't receive that sort of compensation for the mentioning of, it's kind of like product placement, if you will, unless they fully disclose the receipt of such consideration. How much money did they receive for this mention? Rule 144 describes certain types of communications that are not deemed to be a prospectus. So the actual statutory prospectus must follow very specific rules for what it must include. And it's true, whenever you sell a new issue, you can't sell a new issue without giving out a prospectus. Granted, I mentioned before, you can give out a summary prospectus as long as the full statutory prospectus is available for the customer online. That is allowable today. This is just saying the term prospectus does not include the following types of communications. So they're not subject to needing to satisfy the Securities Act of 1933 because they're not prospectuses. So a communication such as the following are not deemed to be prospectuses. Factual information about the legal identity and business location of the issuer, limited to the following: the name of the issuer, the address, phone number, email address of the principal office and contact for investors, the issuer's country of organization, and the geographic areas in which it conducts business. So that's not a prospectus. Doesn't have to follow Section 10 of the Act. Or if the communication discloses the title of the security or securities and the amount or amounts being offered, which title may include a designation as to whether the securities are convertible, exercisable, or exchangeable. And as to the ranking of the securities, that would be fine. A communication that discloses a brief indication of the general type of business of the issuer, limited to the following: So if it's a manufacturing company, the general type of manufacturing, the principal products or classes of products manufactured, the segments in which the company conducts business. And it goes on and describes different kinds of examples there. A communication not deemed to be a prospectus includes a brief description of the intended use of the proceeds. It would include a communication that discloses the name, address, phone number, and email address of the sender of the communication, and the fact that it is participating in or expects to participate in the distribution of the security. A communication disclosing the type of underwriting. A communication disclosing the names of the underwriters participating in the offering. A communication disclosing the anticipated schedule for the offering, including the approximate date upon which the proposed sale to the public will begin, and a description of marketing events, including the dates, times, locations, and procedures for attending or otherwise accessing them. I'm not going to read all of these to you. So there's a whole list of other items also, so make sure that you do read them within the PDF, that are communications not deemed to be a prospectus. So it's under Rule 134 that it lists all of these different types of communications that can be done. If a communication that meets this rule is put out into the public, the following disclosure must accompany any of these communications if the registration statement has not yet become effective, which is very common that the registration is not yet effective, yet we're saying this is when we're having these meetings discussing this issue. So this is the disclosure. It says a registration statement relating to these securities has been filed with the Securities and Exchange Commission but has not yet become effective. These securities may not be sold, nor may offers to buy be accepted prior to the time the registration statement becomes effective. So that's an important disclosure so that people truly understand we can't take your money yet, we can't take your order yet. Also, if the registration has not yet become effective, the name and address of a person or persons from whom a written prospectus for the offering may be obtained. A communication sent or delivered to a person under this section that is accompanied or preceded by a prospectus that meets the requirements of Section 10 of the Securities Act of 1933, including a price range when it's required under rules, may solicit from the recipient of the communication an offer to buy the security or request the recipient to indicate whether he or she might be interested in the security if the communication contains the following or close to the following statement. No offer to buy the securities can be accepted and no part of the purchase price can be received until the registration statement has become effective, and any such offer may be withdrawn or revoked without obligation or commitment of any kind at any time prior to notice of its acceptance given after the effective date. So this is saying if you send out one of those communications, and there's also a red herring, which is really a preliminary prospectus, then it's okay to solicit from the recipient of this communication an offer to buy. So you can take an indication of interest, if you will, but it's not legally binding. But that's only if the communication was accompanied or preceded by a statutory prospectus. So there was this big long list of things deemed not to be a prospectus. So one of the things that's really common, I can still remember when Google had their very first IPO. This was a long time ago, but they took out a one-page tombstone ad in the Wall Street Journal. So this was back when I actually read the Wall Street Journal in paper. Now I just read it on my phone. But it was huge, announcing the issue. So you can imagine in the Wall Street Journal there's no prospectus. So generally the rules will say anytime there's a communication advertising a new issue, it must be accompanied or preceded by a prospectus, unless the communication is one of these communications described under SEC Rule 134. So this big tombstone just announces the issue, says who's the issuer, who are the underwriters, what are we selling, what is the, in this case it had the public offering price. So tombstone ads are not considered, they do not have to have a prospectus with them. Rule 482 is oftentimes called the omitting prospectus rule. It permits material used prior to prospectus delivery. An advertisement that complies with this Rule 482 we sometimes call an omitting prospectus, since it can omit certain information that must be contained in the full statutory prospectus. Because this omitting prospectus doesn't have everything, it may never contain an application to invest and must contain information regarding how to obtain a full prospectus. So the communication under Rule 482 must offer the full prospectus. The Investment Company Act of 1940. I previewed that for you already. So the Investment Company Act of 1940 says there are 3 types of investment companies. You have to know them. So here they are again, and then they'll come back again and again and again, I promise. Management companies, all mutual funds are management companies, unit investment trusts, and face amount certificate companies.